Thank you, Chairman Young. Following this hearing, the Natural Resources Committee will craft legislation on Puerto Rico. To become law, the bill must be bipartisan and balanced. That means we're either going to pass a good bill or no bill at all. If no bill is enacted, the already grave situation in Puerto Rico will get worse. That would not be in the national interest, in the interest of my constituents, or in the interest of Puerto Rico's creditors, many of whom are also my constituents. The drafting process should be informed by two bills that Congress enacted for Washington, D.C. in 1995 and 1997, which are best viewed as a single legislative package. D.C. and Puerto Rico are different in material respects, so the D.C. package should guide, but not dictate, the Puerto Rico bill. The legislation should be holistic, containing three elements. First, the Puerto Rico government has a record of fiscal mismanagement. We must acknowledge this painful fact, vow to do better for our constituents, and accept some temporary assistance along the way. As I have previously stated, I would support the creation of an independent board to approve the Puerto Rico government's financial plan and annual budgets, to confirm that the Puerto Rico government adheres to both throughout the fiscal year, and to ensure the publication of accurate and timely financial information. A board can serve as a bridge to a brighter future, enabling the Puerto Rico government to perform more effectively and regain access to the financial markets. The D.C. board was successful in instilling fiscal discipline only because it had buy-in from local government, business, and labor leaders. To achieve similar support, the Puerto Rico board must be carefully calibrated. As a territory, Puerto Rico has no democracy at the national level. If a bill seeks to extinguish our democracy at the local level, I will do everything in my power to defeat it. Second, the Puerto Rico government must restructure its bonded debt. I say this with regret. Individuals and institutions loaned Puerto Rico money, and Puerto Rico promised to pay them with interest. So you will never hear me vilify creditors. However, while bond-issuing entities in Puerto Rico can pay some of their debts, they cannot pay all of their debts under the current terms and conditions without compromising quality of life and economic growth in the territory to an unacceptable degree. This assertion should not be subject to reasonable dispute. Unlike the states, Puerto Rico has no authority under federal law to restructure debt. There is a consensus among objective observers that Congress should grant Puerto Rico such authority, which would cost taxpayers nothing. I would be open to a provision that requires the Oversight Board to appoint a neutral third party to mediate consensual debt restructuring negotiations between bond-issuing entities in Puerto Rico and their creditors in order to reach agreements that restructure Puerto Rico's debt to a sustainable level, provide fair treatment to creditors, and can be confirmed and enforced by a federal court. When it comes to restructuring authority, I will be flexible regarding the means to the end, but not the end itself. Finally, the legislation should provide Puerto Rico with more state-like treatment under federal programs, because decades of neglect from Washington is the root cause of the territory's economic, fiscal, and migration problems. I join Chairman Young's statement. Puerto Rico should have been treated equally long time ago. Long time ago, Puerto Rico should have joined this union. So, when we ask for state-like treatment, this is not charity or a bailout. This is about fundamental justice. If Puerto Rico were a state, the problems we confront today would not exist, at least not in such severe form. Puerto Rico would have voting representatives in Congress to defend its interests, parity under all federal programs, and access to Chapter 9 of the Federal Bankruptcy Code. Island leaders would not have to come, hat in hand, imploring Congress to grant Puerto Rico rights and powers that every state takes for granted. More equitable treatment is consistent with precedent. The legislative package for D.C. has provided the capital city with billions of dollars in fundings and savings. The forthcoming bill cannot eliminate every inequality Puerto Rico faces because only statehood could accomplish that. But it should make a real effort to mitigate certain disparities. Let me close with an appeal to my colleagues. Before you try to come up with all sorts of clever and convoluted ways to respond to the crisis in Puerto Rico, you should simply extend to the territory those federal programs and policies that have already proven effective in the states that you represent. Resist the urge to experiment with my constituents' lives. Equality is the best policy. Thank you, Chairman.